safe and in your homes. April is Fair Housing Month, and last Saturday, the Fair Housing Act was 52 years old. We typically do a program for the school during April for Fair Housing Month, and we were planning to do one this year, but we had to change our plans when the virus hit. We nevertheless wanted to do something to address the housing issues that we are seeing in this pandemic. I hope you find the information that we're sharing to be useful for you. My name is Allison Bethel, and I am the director of the Fair Housing Clinic at UIC John Marshall Law School. At the clinic, we help people obtain and retain safe and stable housing. Our work has never been more important than it is right now. I am so proud of the work that the clinic has done for the past 25 years and that we are continuing to do. I don't know what people would do in this pandemic without a safe place to call home and to shelter in place. The program today is going to be moderated by one of our clinic students, Maida. Maida will lead the discussion. She will pose questions to the panel, and then she will take any questions that you may have. We want this program to be interactive and useful to you for any questions you may be having about your housing during the pandemic. So with that, I'm going to turn it over to Maida.
Hello, everyone. Thank you for joining us today to discuss issues in housing due to the COVID-19 pandemic. Today, of course, we are joined by Professor Bethel, the director of the Fair Housing Legal Clinic. Alongside with her is Mr. Nicholas Kurtz and Mr. Audrius Alexiunas. They are the staff attorneys at the clinic. And also joining us is our special guest, Mr. Mark Swartz, the executive director of the Lawyers Committee for Better Housing, an agency that specializes in housing and policy. Mr. Swartz has been at the agency for over 10 years now. Thank you for being with us today, and of course, thank you for all the important work that you do. Our speakers today will address certain concerns in relation to housing discrimination and landlord-tenant issues that have become more prevalent during these tough times. This interview will last about 40 minutes. After that time, we will allow for people to ask any other questions they may have. Of course, if you do have a question, simply raise your virtual hand. All right, we could turn to the questions right now. The first one is directed to Mr. Kurtz. So a lot of people are losing their jobs right now. So let's say someone comes to you and says, I lost my job due to the coronavirus and now cannot pay my rent. Can my landlord evict me?
Thank you, Maida, and that's an excellent question. So if you cannot pay your rent, the first thing you need to do is don't panic. There is some time. So you need to determine what you want to do. Do you want to move at this property, out of this property? Do you want to stay? Kind of what your plan of attack is. After you determine that, you'll want to talk to your landlord. So if you want to stay, you need to find some sort of way to pay the money, possibly a payment plan. There's some assistance available that I believe will be talked about a little bit later. If you want to move, you'll need to find a place and discuss with your landlord so you can come to an agreement in writing. Now, most landlords in general sometimes get a bad reputation, so you might be afraid to go with your landlord. When I was practicing prior to coming to John Marshall Law School's Fair Housing Clinic, I was in Flint, Michigan during the height and the beginning of the Flint water crisis. And I did a lot of presentations to landlords, other attorneys, and tenants about what to do in those circumstances, much like what we're facing now with coronavirus. At my previous organization, we anticipated a lot of tenants coming to us saying my landlord wouldn't let me out. That actually did not happen. Landlords were generally very understanding about the circumstances, and just talking to them, tenants were able to come to some agreements and get out of their leases prematurely or set up payment plans or do whatever they needed to do. The same here is true. So in Illinois, there's no self-help for evictions. That means that the landlord cannot legally evict without going through the court process. It's illegal for the landlord to lock you out, remove your belongings, shut off utilities, or kick you out. If this does happen to you, call the police, who will be able to give you access to the apartment again. There's a special order right now in existence during this coronavirus time where an officer should let you into your apartment despite the landlord's objections. Those who are worried about the situation like this should carry a copy of the lease or utility bill to show proof of tenancy. And certainly if you have future issues with that, where the police won't let you in, you should contact an attorney, whether it's the Fair Housing Clinic, Lawyers Committee for Better Housing, or other organizations. The Federal CARES Act provides some protections for tenants if your landlord has a mortgage that's backed by certain lenders, so such as Fannie Mae or Freddie Mac. There's a moratorium on filing eviction cases until July 25th for non-payment of rents and prohibiting late fees for the tenants living in properties with federally backed mortgages. This can sometimes be difficult to know whether or not your property is backed by a federal mortgage. I'd recommend, once again, talking to your landlord about this. In addition to some of the websites, such as Freddie Mac, do have where you can search whether or not the property is held by one of their mortgage service providers. Now, like I mentioned before, a landlord cannot simply just evict you. They first must give you a 5-day notice for non-payment of rent. During those 5 days, if you pay the rent, the landlord cannot proceed with an action in court. Should you not pay within those 5 days, a landlord could proceed by filing an eviction action. In Chicago, under local ordinances, you have a right to pay even after the 5-day notice has expired. Now, there are currently several different orders in effect due to coronavirus. The first is the state order. So under the Illinois Emergency Management Agency Act, all state, county, and local law enforcement officers in the state of Illinois are instructed to cease enforcement of orders of eviction for residential premises during the gubernatorial disaster proclamation. No provision contained in the executive order should be construed, though, as relieving you of any obligation to pay rent. So you still have to pay your rent, but should, during this time, they cannot enforce any orders of eviction. In addition to that, on March 30th of 2020, Cook County Chief Judge Evans entered an order that extends the postponement of many criminal and civil cases in the circuit court through May 18th. So a landlord could still file an eviction action against you, but your hearing likely would not be until after May 18th. No judges are ordering evictions in eviction court, and the sheriff is currently not carrying out any evictions orders in the streets. But this does not stop a landlord from filing an eviction against a tenant. So it's in the tenant's best interest to come to an agreement with that landlord and always put that in writing. Through the city, there is emergency financial assistance to prevent homelessness for individuals who are at risk of eviction, along with other organizations and cities that may have other grants to assist with rental assistance payments. Thanks.
Thank you, Mr. Kurtz. The next question is for Mr. Schwartz. I hope you could hear us.
I can. Can you hear me?
Yes, good. The question is, are there any resources out there to help me pay my rent? Are there any discussions about additional relief for renters?
Yes, there are resources. I think that they're overburdened right now, but I want to point people to the homeless prevention system. There is homeless prevention assistance available for people through 311. You call it, you have to ask for short-term assistance. It's sort of the magic language that lets the people at the 311 call center know that this should go to one of the homeless prevention providers. LCBH is one of the providers, but we typically focus on cases that are in eviction court. Now, at this point, because the eviction court is not active, we may or may not have additional staff resources that we can put to the effort, but we're certainly one of the people that you can call. Now, the short-term emergency money requires that it be for a crisis that's short-term, and that the tenant can show they can pay the rent going forward, and they can't have used the money for the last 2 years. So that's the bad news. The good news is that it's been increased, not because of COVID-19, but because of the Pritzker administration, and they've added additional funding statewide. And so the homeless prevention folks in Chicago, it's administered through all Chicago, felt comfortable raising the amount from $2,500 to $5,000. And that's a pretty significant amount to help somebody with housing stability. Now, with COVID-19, it's unclear how long that money will be available, because we've always had the money run out before the end of the fiscal year. Usually runs out about maybe 6 months into the program. And we had anticipated without COVID that the money would go straight through, but with COVID, it's probably not going to. Now, there's another piece of good news about the homeless prevention dollars. There has been considered effort to try to pivot and provide the money to people who have a COVID-related crisis, because as you may have recognized, you're all very astute, nobody in the COVID context, in this pandemic context, would actually qualify for the short-term assistance, because nobody knows when this is going to end. And if somebody's in the hospitality or other industry impacted by COVID-19, it's very hard for them to establish while they're unemployed that this is a short-term crisis. So the All Chicago has changed the criteria somewhat. First, they've lifted the 2-year this 2-year look-back period where you can't get it if you've already got it within 2 years, so long as this is a new COVID-related emergency. Secondly, if you can show that but for COVID, you would be able to pay your rent going forward, you should qualify. So this all sounds really great. I don't know how well it's working at the moment because of how everybody's systems are very taxed. I will say from the Chicago side, you'll know if you looked at some of the news coverage that they were so overwhelmed by the request for these resources. I think was it $1,000 or $2,000. I mean, they, tens and tens of many times more people asked for it than are going to get it. So it's unclear how long we're going to be able to do this with the money we currently have without additional funding, from other sources. I will say at the federal level, the CARES Act does provide additional, I think it's ESG funds and CDBG funds. And what I'm hearing from folks nationally is that many cities are using these funds for the CDBG funds for homeless prevention and rental assistance. And I think they can use the ESG funds as well. It's unclear what Chicago is going to do, and there's some chatter back and forth about whether it's a legitimate use, but I think that it is. So we're looking to see that there might be more resources available at the federal level. If I could just say one thing, I take one issue with what Professor Kuritz said, although I agree with almost everything he said, and I think it's all very good advice that we should be talking to each other. It's my reading of the law that, and I might have just misheard him, but if a tenant gets a notice and doesn't cure that notice within the 5-day period, if it's a 5-day notice for non-payment of rent or a 10-day for whatever, that's it. You have to cure within that time period. Otherwise, unless there's some kind of agreement from the landlord, once court starts up again, there's no coming back from failing to cure a notice period. Now, that doesn't mean that we can't change the rules, but it would have to be done legislatively. And I think that a lot of people think we really should, because it makes sense. The law abhors a forfeiture. That's this general principle in chancery. And yet in eviction, forfeiture is all that happens. If you miss that 5-day period, it doesn't matter whether somebody comes, from homeless prevention and gives you all the money. If the landlord isn't willing to accept it, you're pretty much out of luck. So let's hope that we can change that so that we all agree that you can cure. And there are some initiatives out there. We are working on a just cause ordinance that the city, the mayor has agreed in principle is a good idea. And that just cause ordinance allows, one of the things it does is it allows people to cure all the way up to the eviction order. Thank you.
Hold up in the back right.
Thank you, Mr. Schwartz. Professor Bethel, I have the next question for you. What if I test positive for the, can you hear me?
Yes.
What if I test positive for the virus or have signs of it? Can I be evicted or my lease not renewed because of that?
So that's a great question. And I have, I guess, a great lawyer's answer for that, which is maybe. It depends. Seriously, COVID, to the extent that it is considered a disability under the Fair Housing Act, there may be an opportunity for you to request a reasonable accommodation. A reasonable accommodation could be any number of things, including perhaps some consideration, maybe an early out, this sort of thing on your lease if you're wanting to get out. We really don't know whether COVID is going to be considered a disability in the sense that we have not had a case on that or anything adjudicated on it. It's going to be on a case-by-case basis. Certainly, if it is a disability, and even assuming that it is a disability, I think another question that would arise that troubles me is that a landlord does not have to continue to rent to someone whose tenancy poses a threat to the health and safety of the community. And certainly that could be a defense that would be raised that would allow a landlord to evict someone who has COVID. This is going to be determined honestly on a case-by-case basis as the data and information we have on it progresses. We would certainly advise folks, though, that to follow all of the guidelines regarding self-isolation, social distancing, and this sort of thing, so that should you be targeted, you could say that you are conducting yourself in a manner that does not pose health and safety threat to the community. Trying to perhaps minimize your exposure to common elements in the building, maybe take the stairs instead of the elevator, if that is feasible. There are limits under the Fair Housing Act if you are a person with a disability in terms of what information the housing provider could ask you for in terms of like information regarding your test results for COVID, if you had it, this sort of thing. So there are measures in place to protect your privacy with the information that you have to provide on your condition. I think at least from my perspective, this is something that, as folks have said, we're all in this together. So I definitely, recommend trying to work with your landlord. There are many people who are not even symptomatic, right? Who may be carriers, and landlords are not going to want to remove everyone in the building. So working collectively and working hopefully in a productive fashion with your landlord to try to put in measures to limit any exposure you may have to other people, I think would be the way to go. I don't know if anyone else has any thoughts on that, but I think the law will continue to evolve on this, and we'll see what happens.
Thank you, Professor. Mr. Alexiunas, tensions are high in my house since the stay-at-home order. My partner is abusive and I need to find another place to live. Can I break my lease? Would I be liable for rent if I left?
Thank you, Maida. Again, that's a very great question and one that really impacts the most vulnerable, I think, in these kinds of situations. And the question really covers a number of issues. First, in the general sense, can a tenant who's suffering from domestic violence terminate their lease early? And generally, the answer is yes. In Illinois, we have the Safe Homes Act, and if a tenant or a member of their household is suffering from domestic abuse, violence, sexual assault, or stalking, a tenant could get out of the lease early if they meet one of those qualifying standards and gives notice, proper notice to their landlord. So there are two ways in this situation where a tenant can break their lease. One is if a tenant or a member of their tenant's household is under a credible imminent threat of domestic or sexual violence at the place where they're living. Or number two, if a tenant or a member of the tenant's household has already experienced sexual violence within the last 60 days at the place where they're living or in the surrounding areas that are controlled by the landlord, such as a parking lot of the building. One thing to note is a credible imminent threat, as defined in the. It is believable that if the tenant did not move or does not move, the tenant could very soon be the victim of domestic or sexual violence. So first, the tenant or the member of their household would have to meet one of those two standards, and then they would have to give proper notice to the landlord. And under the credible imminent threat scenario, the tenant has to give the landlord 3 days written notice that the tenant will leave the unit because of the credible imminent threat. Under the scenario of the tenant already having experienced sexual violence within the last 60 days, the tenant has to give the landlord 3 days written notice that the tenant is leaving due to the sexual violence, and that the notice must include the date of the incident, and the tenant has to give the landlord proof that the tenant has been the victim of sexual assault, abuse, or stalking within the last 60 days. And proof, in this case, can be from medical reports, court or police evidence of sexual violence, or even a statement from an employee of a victim services or rape where the tenant has gone to for services. The tenant cannot reasonably give notice within 60 days of the incident because, let's say, for instance, the tenant was hospitalized during that time. The tenant has to give notice then as soon as thereafter possible. Some other things to note in this situation is if a landlord, after the tenant vacates the unit, if a landlord then tries to collect rent from that tenant, the tenant would not be liable for rent if they left under one of those credible reasons and gave the landlord proper notice. Also, if the tenant does leave under those circumstances, that original landlord cannot then tell other future landlords of that tenant that the tenant left, that the tenant broke their lease early due to being a victim of domestic violence. So in case the tenant, starts renting looking for other places, and the new landlord calls for a reference, the old landlord can't divulge that information. So another issue that comes up in this question is, and this has to do more with COVID-19 specifically, is can the tenant move during this stay-at-home order? And the answer in general is yes, they can. The stay-at-home order is geared towards mostly limiting gatherings of people of 10 or more, gatherings of people in restaurants or bars, or just basically where social distancing is taking place. It does lay out specifically the stay-at-home order in Illinois that if a resident is feeling unsafe or is unsafe in their residence, that they are urged to find a safe living situation. So in the situation of being a victim of domestic violence, the tenant is not only allowed to move, but they are urged to find a safe for themselves and their family members. Another issue that comes up in this question is besides moving away from the situation, can a tenant in this situation get an order of protection? Today, due to the shutdown, most courts are closed for most purposes, but judges and courts are available for emergency matters, which an order of protection would be considered an emergency matter. So depending on the court, there are capabilities of courts and judges hearing protective order requests either through video conferences or telephone conferences. Again, that depends on the court and their sub for hearing emergency matters, but that is an available option for this tenant. And then finally, once the tenant does find a place and has acquired an order of protection, can that order of protection be used against the tenant? And in Illinois, the answer is generally no, that tenant's status as someone who has a order of protection is a protected class. And a landlord cannot use that order of protection status to discriminate against the tenant. Some other things to note regarding this question. There could be other applicable laws in helping this tenant, such as the Violence Against Women's Act, which has to do with subsidized housing, public housing. It's also important to note under the Same Homes Act that I was talking about a tenant and a member of their household. Member of household extends beyond just the unit itself. It could extend to people living within the neighbors who are also being subjected to the abuse or the stalking or whatever the tenant is being the victim of. Not sure if any Professor Bethel or Kurtz or Mr. Schwartz have anything else to add to that, but again, that was a great question that covers a lot of areas that are going on right now.
Yeah, I don't have anything to just say. This is something that our networks are reporting is indeed on the rise as people self-quarantine, and something to really be aware of. And
So as we all know, our school is closed and all of the other universities across the country are closed. And kids students, I should say, don't know what to do with their leases and if they want to move back home. So Mr. Alexiunas, what should I do if I want to terminate my lease early since the university is closed and all the classes are online and I want to go back home to save money?
Thanks, Maida. Again, great question, and a question I think a lot of as the question poses, a lot of students are facing at this time. And unfortunately, I don't have a clear-cut great answer for that because in general, it doesn't appear that there is a legal justification for breaking your lease due to life change by the COVID-19 pandemic. But as we've sort of alluded to in some of our previous answers, one of the best options could be to just talk to your landlord and try to negotiate some way to end your lease early with small or no penalty fees. One of these options could be, like I said, to try to reach an agreement with the landlord. It's best to give the landlord as much notice as possible. And also another point to make is any agreement you do make with your landlord to end the lease early, you should definitely make it in writing and signed by both the landlord and the tenant. And some things you want to cover in that agreement could be the date of the termination, termination of utilities, the release of the tenant from the lease with no further rent due, any due dates and amounts of any agreed upon compensation to the landlord, and whether the security deposit will be forfeited or returned. Another sort of negotiation tip for a tenant in this situation could be to review your lease and look for any act of God clauses. or frustration of purpose clauses, which in this situation, if an apartment can't be used for what it was typically rented for, then the lease could be terminated. And like I said, it's unclear whether the pandemic could be considered an act of God, but it could definitely be something to help a tenant negotiate with the landlord in this situation. A couple of other options for a tenant could be to find to sublease the unit, which in this case, the original tenant would have to make sure the subtenant meets the landlord's reasonable requirements. The original tenant remains responsible and that none of the lease terms are broken. Another option for a tenant in this situation would try to be to assign the unit to someone else, which in that case, the landlord would terminate the original lease with the original tenant, assign it to the new tenant, and the original tenant would have any liability under the original lease. Like I said, it's not a perfect answer, but it is, from what I've seen, sort of the best option right now. Not sure from Professor Bethel, Mr. Kurtz, Mr. Schwartz, if you have any input regarding this situation.
I mean, I'll just add one thing. I think that's very thorough. I've been in the industry for a while, and one of our things we could do in private practice sometimes is try to help people get out of leases. And so I'll say one additional thing that if you can do it, you should. It's much better to terminate a lease than to break a lease. Now, if there's an act of God clause or something, sure, that would be one way to terminate. In Chicago, we have the residential landlord tenant ordinance, and the landlord needs to attach a summary, and the summary's got to be up to date. And people are becoming really professional and know how to manage properties much better than they have in the past. And so I rarely see defective RLTO summaries or no RLTO summaries, but I do see them. And so if people want out of their lease, the very first thing they should do is just look and see if there's a summary, or if it's a current summary. It should say Mayor Lightfoot. If it doesn't, then it's not current. And if the summary isn't there, you can terminate the lease under the RLTO, and you can even ask for $100 for your trouble. So that's sort of a get out of your lease free clause tip from me. It doesn't happen all that often anymore.
Good advice, Mark. I'll just mention quickly that, so the question that might have posed had the student needing to leave to save money. If the student is ill, or maybe one of their family members are ill and they're trying to go back and take care of them or get help for their condition, there may be an argument that you can raise for reasonable accommodation versus through your association with someone who is disabled, or through your own disability. Again, if there's some, this is more, it's a case-by-case basis. There's some unclear answers with that, but that may help a little if you've really got to get out of there to help take care of a sick family member, or you yourself may be ill.
Thanks for all those responses. Professor Bethel, it has been reported that minority communities are disproportionately impacted by the virus. Why is that the case, and what can be done about it?
Yeah, so this is a very troubling question, and I think that as the pandemic progresses, we're going to get more really very disturbing data on it. Chicago's housing market before the pandemic was in many ways very sick. It had pre-existing conditions, just like many of the COVID victims. It had pre-existing conditions due to decades of inequality and institutional racism. And the conditions include hyper segregation, the lack of safe, affordable housing, the lack of accessible housing for people with disabilities and other illnesses for the housing market. And just like COVID has shown itself to be more dangerous and more deadly for people with pre-existing conditions. It is more dangerous and deadly for communities like Chicago that have pre-existing extreme racial segregation. And the disinvestment in minority communities has contributed to generations of health conditions for the people in those communities to make them more susceptible to this virus. So how we respond going forward in terms of not only the virus, but looking further, how we respond once we get out of this, how we respond in helping to rebuild and develop healthier communities, I think will impact how strong we can make our communities for a second wave, and even future pandemics. And we have just got to do better at healing our sick housing market in Chicago.
Thank you, Professor Bethel. Mr. Kurtz, I went to apply for an apartment, but they would not rent to me because I lost my job due to the coronavirus and am now unemployed. Can they do that?
That's also a really great question. And I will give you, once again, a lawyer's answer. It depends. So in Cook County and the city of Chicago, we have source of income protections under the local fair housing ordinances. This means that landlords cannot discriminate based on a lawful source of income. Because unemployment is a lawful source of income, there may be a fair housing issue that exists here. Should you encounter something like this, we would recommend that you contact either the Fair Housing Clinic or another organization to further assess this, because there are many options or many reasons why a landlord may be denying you. It could be because of the unemployment, which could be problematic, or there could be other reasons such as credit scores, rental history, etc. So to do a full assessment of the case, it's best to look at the holistic view and contact either us or, like I said, another organization. These cases must be filed within the City of Chicago Commission or Cook County Commission. Unfortunately, there's no immediate court remedy under these ordinances because you have to file with the commission. The commissions are currently closed right now, but these cases need to be filed within 300 days. So once again, you would want to contact the clinic for further assessment of a case like that. I don't know if Audrius or Professor Bethel or Mr. Schwartz has anything else on this. And then if not, or after this, we did get a question that came through the chat. So after we're done with this, I'll do that real quick.
Yeah, and I would just say that we at the clinic have had some cases in the past dealing with temporary government type benefits under source of income. And while, again, we don't know exactly how the commission will treat these cases arising out of COVID, but certainly one of the arguments that we have raised is that in other cases is that there is no guarantee that a person whose source of income is their job, that they won't lose their job. So to hold people on government assistance, albeit temporary assistance, to such a high standard is unfair and treats them differently than other protected classes. So, and we've had some inquiries about this that we're looking into. So look for more on this issue in the times to come. The service industry, particularly, being hit hard by this kind of thing.
We did. Thank you, Professor Bethel. We had a question come through. Individual is wondering if the landlord would be forced to use a security deposit if the tenant cannot pay due to coronavirus. I'm not sure who would like to take that question.
I mean, I'm happy to. The landlord can, but they don't have to. The security deposit is something that they can apply to unpaid rent or damages. But if the landlord wants to, not apply that security deposit. They're able to act as though the rent hasn't been paid. Now, I'll go back to my former answer. I used to be in the business back when I was in private practice, and the RL residential landlord tenant ordinance does have some pretty severe security deposit penalties, but everybody more or less is doing it very right now. Although if they're not, you should talk to an attorney. Unfortunately, also, most people these days are avoiding security deposits and going to the move-in fees. And those things are just, that's just money that's gone. People aren't able to ever recover that because they're move-in fees, even though they're not in any way attached to actual real costs. So that's all I have to say about security deposits. Thanks.
All right, I think we have time for one more question. This goes to Mr. Alex Yunus. The president called this the Chinese virus. Can landlords evict Chinese people because the virus reportedly came from China?
Thanks, Maida. Interesting question. So the Fair Housing Act prohibits discrimination in housing based on a person's national origin. So it's unlawful for a landlord to treat someone differently because of their national origin, which includes someone's birthplace, ethnicity, ancestry, culture, and language. So, national origin could also include either a region within a country or a region that spans multiple countries. So, in general, no, a landlord can't lawfully evict someone because the person's Chinese. Even if the tenant isn't Chinese, landlord doesn't need to know a person's particular national origin, or the landlord could even be mistaken about a person's national origin, and the Fair Housing Act could still be violated. It's also worth noting that the Fair Housing Act protects everyone, regardless of a person's immigration status. So it's unlawful for a landlord to ask tenant questions about their immigration status or to look into that because of the tenant's looks, talks, or how the tenant dresses. Not sure if anyone else has anything to add to that, but thanks.
Yeah, no, I think that was a great answer, and unfortunately, that was a unfortunate characterization of the virus. It's not Chinese. Frankly, it is equal opportunity killer.
Thank you, Professor Bethel. Looks like we're out of time, so we'll just open this up to anybody who has questions. If you do have a question, you can simply hover your mouse over your name and it has like a virtual hand that you could press, and then we will see if anyone has a question.
I think Mr. Yu had a question.
I had a question. Sorry, I was starting to type it out in the chat, but it didn't go through fully. But my question, more generally, would be what role? This is for anybody. What role do you see law students and law schools playing in providing legal services or legal assistance during COVID-19? Just general thoughts on that.
Well,
Yeah. Go ahead. Go ahead. Whoever started.
I was just going to say, my legal aid agency relies heavily on legal interns. The problem for us is that we, in this remote learning environment, would have a really hard time getting people geared up. But I think that if we can figure out a way, maybe through some kind of virtual training, to get people to help assist with these communications with between the tenant and the landlord that the other presenters have talked about, which is recommended. Try to work something out, and see if there's a way that students, maybe through the supervision of a clinical director or a legal aid agency, could help make sure that tenants weren't coerced or entering into unfair agreements. It's one thing to say, go and make all these agreements, but people who have been in the business a long time on the landlord side, they pretty much know how to frame things to their benefit. And sadly, because the moratorium doesn't affect the notice periods and people can still get these notices and the notices expire pretty quickly, tenants can agree to maybe pay partial payments, but the law still stands that a partial payment isn't enough and it's got to happen within those 5 days. So there are ways to waive all of this, but in order to do it, you need to make sure that it's in writing in a really good way. I'd also recommend maybe Metropolitan Tenants Organization. They might be able to help. You could use their manual, and they might be able to utilize you not so much as a somebody under an attorney, so not as a lawyer under a 711 certificate, but maybe just as a tenant advocate, and then you could do a lot of really good work because their manual is pretty robust and will help you with how to frame agreements and things like that, or termination agreements and the like.
Yeah, and we're definitely looking, at the clinic, we're looking to file cases, and the students do that, from intake to filing to final resolution. Although, of course, the courthouse and everybody's closed right now. But actually, when things open up, we will be looking at that. And I'd also say, too, that I think, I know I have heard, and Mark, you may have heard, too, of some additional reforms that folks are looking at proposing in Chicago and federally to provide additional relief for renters and the public affected by this. So we look to have some maybe advocacy initiatives going, and maybe students can join in those. I really appreciate the question because I think that that's where we need to be going. Like, what can we do to help people affected by this? What can we do should this happen in the future and better position ourselves? And we're looking for students to help us with some more innovative strategies, some new strategies, and to join in globally. Litigation is one way to do it, but I know Mark and I have talked about rent reforms, yes, in Chicago that might make people better able to withstand other crises in the future. So these are all ways that students can get involved, students and just really members of the public.
If I could just add on to that, because that reminded me of a couple of other really good things. So we are anticipating that once courts open up again, that there's going to be like a huge avalanche of evictions. And at that point, I think the legal aid and clinical community are going to, need to gear up, and maybe we can come up with a way to get everybody trained up to help us in the effort. I don't know. It's hard, but I think that it's necessary. I'm always really careful about, I want people to be well trained before they go, but it's necessary, so it has to happen. The second thing is there are so many policy initiatives that you all can get involved with right now. There's the Lift the Ban Coalition. Right now we aren't allowed to regulate rent, stabilize rent, control rent at the local level because at the state level there's a ban on rent control. Look ahead. There's going to be some housing reforms that are emergency reforms taking place at the state level as well, where we could get involved. They're going to be passed. There's a new housing working group in the legislature that is going to be working on things, and you're going to want to make your voice heard And then at the city level, there are a lot of permanent things that we were looking at before COVID-19, and we got derailed because all this stuff would be really relevant for COVID-19, but right now everybody's thinking about life and death, as they should be. And so I'm thinking about the just cause protections for renters, where if we had just cause, we wouldn't be able to push renters out because they were Chinese. And if we had just cause, we could add something for the emergency to say that maybe people impacted by COVID can't be evicted under just cause. But we don't have just cause right now. The mayor has stated that it's one of her housing one of the things that are on her housing platform, but it just isn't there right now, and the details are still a little murky as to what just cause will look like in Chicago. And then right to counsel. Hopefully when everybody gets out of law school, there'll be a right to counsel in Chicago, and people will be able to pile in because it's really great work, and you can start working on right to counsel. And that's the Department of Housing in Chicago has stated in principle that they're for right to counsel. And so if you look at all of the technical things about eviction that will make it very hard to defend for people once eviction court starts again, this is the time where you need lawyers to dig in and look at the very few germane defenses in eviction court, like retaliation, implied warranty of habitability, and all that. And if we had a right to counsel movement, well, that would be pretty terrific, but we don't. But all those things, need people to advocate for. Lawyers Committee for Better Housing, we partner, and we're sort of administrators of this group called the Housing Justice League. It's very tongue-in-cheek, the name, but that has all the platforms that I'm talking about. So if you look up Housing Justice League, you could get involved.
Thank you, Mr. Schwartz. If anybody else has any other questions, please feel free to chime in. All right, I guess, we'll just conclude here. I want to thank everybody who tuned in today and all the speakers that we had. Fair housing is really important, especially right now when everyone's kind of facing tough times. So it's important that we all work together. If anyone does have any questions or knows somebody who needs help, feel free to contact the Fair Housing Clinic. Be safe and stay healthy. Thank you.